Imagine handing over your life savings, taking the keys to your new home, and moving your furniture in, only to have the door slam shut on your legal rights because you don't actually own the property. The 1990 Rama Reddy Supreme Court case shows exactly how this happens. Physical possession means absolutely nothing without the correct paperwork. In that case, a buyer named Muni Shamappa paid the full asking price of 23,000 rupees and was handed the keys based on a signed agreement, but the seller never executed a final registered deed. Under the Transfer of Property Act, an agreement to sell does not transfer title. It simply records an intent to buy in the future. Relying on that initial promise gives you protection under contract law, meaning you can sue for a refund. It does not give you property law protection, meaning you do not legally own the house. Until the final document is signed and registered, the seller retains the legal title. You, the buyer, cannot legally mortgage the property, sell it to someone else, or defend your ownership in court. Relying on a mere agreement leaves you shouldering a massive financial burden while holding zero legal title. It forces buyers into decades of court battles just to force a legal transfer. To navigate a purchase safely, you have to separate intent from execution. The sale agreement is an executory contract. It's a legally binding statement of your intent to buy that locks in price and timeline. During this agreement phase, the physical and legal risks, like property damage or sudden title disputes, remain strictly with the seller. This split-screen table compares the two phases. On the left, the sale agreement must include strict conditions, penalties for delay, exact possession dates, and clear title confirmation. On the right is the sale deed. This is the finalized, executed contract that affects the actual, irrevocable transfer of property rights. The exact moment the sale deed is registered, the property risk, the tax liability, and full ownership rights instantly shift to you, the buyer. Inserting strict clauses into the initial agreement requires tense negotiations up front, but it is the only way to hold a builder financially accountable for delays or defects. The sale agreement secures the property and takes it off the market, but the sale deed is the specific legal document that actually transfers ownership rights and provides you with the title to your investment. Because registering a sale deed requires paying stamp duty, typically 5 to 7% of the property value, buyers are frequently tempted to take legal shortcuts. The most dangerous shortcut is the general power of attorney, or GPA trap. This is where a buyer pays for a property, but it subs a power of attorney document instead of a registered deed. In the landmark Suraj Lamp case, the Supreme Court completely invalidated GPA-only property transfers. The trade-off is devastating. You avoid paying stamp duty today, but you acquire an unsellable, legally void asset that the original owner can reclaim. The only legal alternative is executing and registering the sale deed with the local sub-registrar. This checklist shows the critical paperwork the sub-registrar demands to legally validate the transaction, starting with Aadhaar and PAN cards, prior encumbrance certificates, and 2 witnesses. If the property is valued over 50 lakhs, you must also provide proof of tax deducted at source, or TDS. Failing to provide accurate property schedules or these clearance certificates will immediately halt the registration process. Gathering this meticulous paperwork creates high upfront friction, but it prevents your registration document from being challenged or thrown out of court decades later. Securing a clear property title in India requires following a strict, multi-stage legal sequence that prioritizes procedural accuracy over speed. This flowchart maps out the chronological path. E-pay a token, conduct legal checks, sign the sale agreement, apply for a loan, register the deed, take possession, and mutate the records. Steps 2 and 3 differ depending on what you are buying. First-time buyers looking at new builds must verify the project's RERA registration online before signing any sale agreement. Running this check limits your options to compliant builders, but it strictly protects you from abandoned projects and fraud by confirming that the construction plans are government-sanctioned. Resale buyers face a different set of hazards. Instead of construction risks, you are taking on massive title risks. As a resale buyer, you must demand a 13 to 30-year encumbrance certificate and the original mother deed before drafting the final sale deed. Paying for this extra verification costs time and legal fees, but it proves an unbroken chain of ownership and ensures you don't inherit the previous owner's secret mortgages. There is one final administrative step that happens after you take possession: mutation. Mutation at the municipal office updates the government tax records to reflect your name. You cannot legally set up utilities or pay property taxes until this is done. The time spent on rigorous due diligence, from lawyer fees to bureaucratic delays, is the necessary investment to ensure that your ownership stands up in a court of law and that your capital